Welcome back to Time Serve, the channel that's get the docket so you don't have to. The dynamic duo of 14B is at it again, and this time Mr. Holly breaks the law, doesn't listen to judge's orders, then wants the judge to hear him out.
Wrong.
Will we see a hammer drop in the 14B? We shall see. Oh boy. Like and subscribe, set your notifications to all. Let's roll, nerds.
Before we call the matters of Brian Holly, case numbers 21S00163, 21T00282, 22S00523, and 23S00528.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Holly, who appears to be assumed from the jail. Mr. Holly, can you please state your name for the record?
Yes, Brian Idell Holly.
Good morning, Mr. Holly. Good morning, Mr. Barnett and Mr. Bellinger.
Good morning.
Good morning, Your Honor.
Your Honor,
Go ahead.
it's my understanding we're here for pretrials this morning. I made a late discovery, unfortunately, that we didn't have the correct discovery for the telecommunication services case. When I'd spoken with Mr. Holly, we'd been talking about global resolutions. We hadn't looked at that case in particular. I have made the request to get that corrected this morning, and that is being sent over, is my understanding, so that we can review that. So we would be asking for an adjournment on these matters. This would allow for more conversation, hopefully for a global resolution, and I would ask to address bond at the appropriate time as well.
You may at this time.
Thank you. Mr. Holly is in on a $25,000 bond. He's been in for some time now. He has some pretty heavy family stuff going on right now. We would be asking for the court's consideration for a GPS tether in lieu of him remaining in jail. He would like to get out. He'd like to start working. He'd like to be able to prove to the court that he's capable of being out without absconding. He understands that the court considers him to be a flight risk, considering the 2 years that went by where he was absconding. That said, it has been a minute now that he's been in jail. He does take these matters very seriously, and he does wish to remain and challenge them. He's been in this community for 20 years in this general location, and so he's not going anywhere.
Thank you, Mr. Barnett.
Your Honor, I'll leave it in your discretion ultimately, but this is a rather old case. I believe he didn't appear at a final settlement conference. The allegations in the case are that there was a crash and a blood alcohol level of 0.221.
Thank you.
Your Honor, if I may respond on behalf of the state.
You may.
As Your Honor called, Mr. Holly is here on 4 cases. 2 of those are the older ones, which are the child abuse case from the state, as well as the high BAC case from Mr. Barnett that he just discussed. When Mr. Holly absconded, it was a combination of him not testing, or I believe after testing positive, but not testing at all, as well as not showing up. The subsequent 2 cases that we have from Mr. Holly are another child abuse related allegation, as well as malicious use of telecommunications with Ms. Christine Hickman, mother of those children. The last time we were here at the pretrial, I mentioned that Mr. Holly had made some calls from jail, specifically instructing Ms. Hickman not to come to court and participate. And she apparently changed her mind about what she plans to do, even regardless of her intentions for planning to come to court after that conversation. I did indicate that I would be looking further into that to find out if there was enough to substantiate a felony charge, and I would certainly be proceeding with that if there was. Mr. Holly has continued to contact the people he's not supposed to have contact with after that hearing. In fact, discussing on one of those calls the fact that we brought this up in court and that I heard those calls previously. Mr. Holly currently has a no contact order with Ms. Hickman and with all of the children, given that there are direct allegations involving each one of those parties. He has since spoken to them, and also had a call with another individual where he made it very plain that he was not going to not only plead to anything, which he certainly has a right. Mr. Holly can exercise his full rights to have a jury trial on each one of these 4 cases. But he mentioned that he was not pleading to anything, and he was not going to be on anybody's tether whatsoever. He said that he was going to leave that jail with nothing. he was going to stop drinking if he decided to do so on his own terms. So given the fact that there are continuous bond violations that not only reflect upon no contact orders, and the fact that Mr. Holly, I understand, is eager to get back to his family and work out his problems on his own terms, but right now, the allegations are against every member of that family, and we're still violating no contact orders. Alcohol is an issue in each one of these cases as well. I don't see why continuous violations of bond would merit any sort of favors in a release to continue doing so. I don't know what has been provided to the court or to the people or to Mr. Barnett that would be any reassurance that all of this is going to change if we reward that behavior.
Thank you.
No,
Any-
can I say something?
You may not. I think you said enough in your phone calls, don't you?
I just would like to say that it's imperative, Your Honor. I'm just concerned about my children. The case with my son, he's now locked up in a juvenile facility across the street, Your Honor. He was caught with a loaded gun. I apologize. I know I went against the code of the court, and I'm truly sorry about that. But one thing I would like to make the court aware of is that I love my children, Your Honor, and I'm scared for him. I'm scared for my children. I know I made mistakes, and I'm here not to go against nothing you guys are saying. I'm here specifically to take accountability for what I have done. The reason I have talked to my children, to talk to her mother, is strictly based on caring and being concerned about them. I've been in here 31 days, Your Honor. I've had no sleep. I've been very stressed about and worrying about my child. Now the situation that happened, I'm not gonna go too far in detail because I know this is not the time. Parent tells child to do right in school. Listen to the teacher. Do what you're supposed to. Don't get in trouble. The reply he says is, F you, I do what I want. I say, give me your phone. Go in your room. He goes to the room. He gets another phone. He calls the police.
All right, Mr. Holly, you're treading here. Be careful.
I'm just trying to.
I know.
I'm gonna make this short because she's giving me an opportunity to speak.
Actually, I didn't. You did exactly what I said.
I'm sorry, ma'am. I'm sorry, ma'am. I'm hearing all this, and it hurts. It hurts to even hear these allegations put on me. I'm a parent, and I know I have not made all the corrective choices, but I just want the court to know. I just want the court to know that it sounds bad, but I love my children. I will never hurt them. I'm just guilty of not knowing what to do at times. I'm a hardworking citizen. I've been around this county for 20 years. I work. I do what I'm supposed to do. I have not committed any atrocities in terms of crimes. I've made mistakes. I made mistakes, Your Honor, and I'm accepting accountability for that. I promise you I am. But what I'm not is a threat to society. I'm not a threat to the world, and I'm definitely not a threat to my children. But what I do know is that my son was just put in a juvenile facility. He's on probation, Your Honor. He has a GPS teller on his leg right now. He's only 13. He was just caught with a loaded pistol. This is what I was trying to prevent. And in doing so, I was lied on and said that I
Okay, Mr. Holly, careful, you're treading here again.
Okay, I'm done. I'm sorry, Your Honor. I'm sorry. I just feel these allegations is making me look brutally bad when I know I made mistakes. I'm taking accountability for this. But I promise you, I just want to be out to do a better job in raising my children so I can move on with my life. I would accept any stipulation that the prosecutor agreed to, a teller, alcohol monitor, anything, and I will abide by that. And I promise you I will. I just feel like I have such more duties out there than I do in here. And I know I'm a contribute to the world, not being in here. And I just want an opportunity to prove that. And if you guys can just give me another chance, I promise you I will abide by any stipulation that's given by the court.
Sir, all you've proven to me so far is you will not follow any of my orders or directions at all. I told you not to speak, and now you've been speaking for about
I'm sorry.
maybe 7 to 8 minutes. I told you not to make any additional phone calls. You did that. I told you to show up for court. You didn't do that. So pretty much everything I've ordered you to do, you've done the opposite of it. And you sit here telling me that you haven't done anything, when in fact you're before this court on 4 separate cases, including one, which is drinking and driving involving a crash. Bond request is denied.
Thank you, Your Honor.
What date would you like to come back? Either November 13th, November 20th?
I think November 20th or November 13th would be best, Your Honor.
You're gonna be ready in a week?
I can be ready in a week. We expect to get that that discovery sometime in the next couple of days, and I will review that with them, and then we will either set these for trial or seek to resolve.
And I'm going to trial, bro. Not pleading guilty to none of this. It's all absurd.
Well,
And
we
y'all
can certainly
not find me guilty. Y'all wasting taxpayers' money. I don't care what.
Your Honor, we can certainly set these for jury trial at this time. It would still give us time to review the new discovery. If we want to set it for a final settlement conference, it might be best at this point.
Your Honor,
Yes.
I'm sorry, no objection to that. I just wanted to bring up, the court mentioned that also with the last pretrial. Mr. Holly seems to be fixated on one of these cases in particular. The earliest case is a child abuse case involving Ms. Sierra Holly, who actually did appear for the final settlement conference. Mr. Bellinger, I hope you have full discovery on that, including the supplemental reports with the photos of her in the hospital and all the CPS attachments that go with that. So, so we would not be needing to produce her, as well as the fact that she is a minor in a child abuse case, and she would need to be produced for trial by the adult that currently has the care of her. So this will not be a case of somebody not showing up.
On December the 16th, 2021, it looks like the witness Sierra Holly was present and excused for future dates. So she does not need to be present. I wrote that in my notes myself.
Okay.
So that one will be going to trial definitively.
I will be found not guilty. Innocent until proven guilty.
All right, Mr. Holly, please be
Innocent until proven guilty.
understood.
Sir, if you keep speaking out, then I'm going to hold you in contempt of court. Any contempt will be run consecutive to any time you have to do. Do you understand?
Yes.
November 16th, 2023 at 9 a.m. for final settlement conference. And December 1st. I'm sorry, that should be 11 a.m. for the final settlement conference. December 1st, 2023 at 9 a.m. for the jury selection. The defendant needs to have proper clothing so that he appears appropriately before the jury on that date. So please make sure that he is prepared for that date.
Okay.
And Your Honor, I will be submitting an amended complaint. There is an error on the case that Mr. Holly is so fixated on with his older son, I believe. And so I was just incorporating, I was going to dismiss that case with the global resolution, but since we're going to proceed on it, I do need to make a change to it. So I will submit that to the court ASAP.
Please submit it as soon as possible so that they can be prepared for the trial.
Will do.
Thank you. You're all set, Mr. Holly. I see you on November 16th. State of Michigan versus Denali Deloche, case number 20.